Welcome to the Accommodations in the Workplace at the Supreme Court panel. I know what many of you are thinking. Gene, Schaerr, you look different. Have you done something with your hair? Gene, unfortunately, had his flight canceled last night, so he's going to be a little late today. He'll miss this panel, so I'm going to pinch hit for him. My name is James Phillips. I'm an assistant professor of law at Chapman University. So I'm just going to briefly do some introductions and give a few background remarks and then turn it over to our panelists. And I'm going to keep these introductions brief since we can all hop on the internet and find out pretty much more than we ever wanted to know about anybody these days. Nathan Diament is the executive director at the Union of Orthodox Jewish Congregations of America. He's been there for 27 years, which is my wife would be very envious of that kind of professional stability. He was undergrad at Yeshiva University, and he earned a law degree at Harvard Law School. Todd McFarland, here on the end, is the Deputy General Counsel of the General Conference of Seventh-day Adventists. He has been there for 17 years and initially went to Southern Adventist University in Tennessee and then earned his law degree from the University of Illinois at Urbana-Champaign. So I just want to briefly set the stage a little bit before we turn it over to our distinguished panelists. The Supreme Court has been playing around the edges, you might say, of religious liberty and workplace for about a decade, and now has a case before it that we're going to talk about that kind of directly addresses that issue. But I just wanted to hit some of those highlights as a background. So again, some of this is somewhat tangential, but in this context. So you'll remember the Hobby Lobby case from 2014, I believe it was, which was whether a family-owned corporation, or rather large corporation, but a family-owned corporation had religious liberty rights under the Religious Freedom Restoration Act. And then the next year you got a case called Equal Employment Opportunity Commission versus Abercrombie and Fitch, which dealt with a Muslim woman who was applying for a job and didn't get it because she wore a headscarf, and that was kind of against the policy of the company. And that involved Title VII, which Nathan's going to talk to us a little bit more about. In 2018, you had the Masterpiece Cake Shop case, which involved a baker who owned his own bake shop. So he was the owner, operator, and also a baker. He had employees, and he made custom cakes. And he did not want to sell a custom-made cake to a same-sex couple for their marriage. He was willing to sell them one off the shelf. And that was found to run aground of Colorado's anti-discrimination laws. And the Supreme Court ended up ruling in favor of the baker on religious freedom grounds, but not somewhat kind of tangential grounds in the way he was treated by state commissions who were investigating this. They were saying they did so in a biased manner. It wasn't necessarily that he had a religious freedom claim to not bake the cake. So in all three of these so far, Hobby Lobby, the Abercrombie and Fitch, where the court ruled in favor of the Muslim woman, Masterpiece Cake Shop, we see the court kind of siding on religious freedom side. Then we get just a couple years ago, or just a year ago, we had the Kennedy case, Coach Kennedy, a high school football coach who, after football games, wanted to pray on the field. And this raised free exercise and free speech and establishment clause issues. And there the court ruled in favor of the coach's ability to do that. In that case, of course, what's unique is that the employer was the government. It was an arm of the state. And so that brought in free exercise and free speech. We have a couple of cases right now before the court. One's called 303 Creative, which involves a woman out of Minnesota, if I recall, who was it? She's Colorado as well. And she is a wedding photographer, has her own business, and does not want to, for religious reasons, to take pictures of same-sex weddings, and wants to be able to put that on her website. I don't do same-sex weddings for religious reasons, and has gone up to the court, but purely on free speech grounds, even though this is motivated by religion. And then the other case where we're getting squarely the Supreme Court addressing the right of religious liberty against one's private employer in the workplace is Groff versus DeJoy that we'll get into today. So the court has been kind of in this area, never squarely until now, and so far has tended to hand victories to the folks who are raising religious liberty claims in work and business-related areas. So with that, I'm going to turn it over to Nathan, and he's going to talk a little bit about Title VII.
Oh, good morning. Sorry, it's afternoon on the East Coast, and there goes my name tag. That's fine. It's a pleasure to be with you all. Don't worry about it. Thank you. It's a pleasure to be with you all here. My first time here at BYU. It's very exciting. It's very picturesque. So as was said, the court has this case, Groff versus DeJoy. Groff is a devout Christian postman working for the U.S. Postal Service, and did not want to be working on Sundays. And many of you might be saying, wait a second, the post office doesn't work on Sundays. And yes, that was true until somewhat recently, when the U.S. Postal Service, always trying to become more fiscally successful than it ever has, entered into a business arrangement with Amazon. And so U.S. Postal Service workers in many parts of the country, I presume in Utah, will deliver your Amazon packages on Sundays. And this posed a challenge to Mr. Groff, and Todd will get into it more in the details, but long story short, he was not willing to work on Sundays, and the Postal Service ultimately could not accommodate that. And so he lost his job and sued, and his case is before the Supreme Court. But to rewind how we got here, we have to go back to 1964 and the passage of the Civil Rights Act, which Title VII of which deals with employment discrimination and prohibits employment discrimination on the basis of, among other things, religion. In 1964, when the act was written, that essentially meant you couldn't refuse to hire somebody or you couldn't fire somebody just because they were fill in the blank, Jewish, Catholic, Muslim, what have you. But it was not until a few years later that it specifically, Congress amended Title VII to include something about religious accommodation on the job. In the intervening time, I'll get to that in a second, in 1967, before Congress legislated, the EEOC, the Equal Employment Opportunity Commission, after receiving various complaints and requests for guidance about accommodating workers' religious requests on the job, did start issuing some guidance. The guidance in 1967 talked about employers are to accommodate so long as their employees' request, so long as doing so would not create what the EEOC said was a serious inconvenience, quote unquote, to the business. But even then in 1967, along with that guidance, they had, the EEOC included many examples which didn't give that a lot of strength for the employees' side of the equation. The guidance even said that a job applicant, for example, knowing that he or she could not work the full work week, because they had to have off on a Saturday or a Sunday or a religious holiday, is not entitled in the 67 guidance to demand such a schedule change for their employer, right? And so in 1968, then the EEOC issued updated guidance. It's the first time the term undue hardship is used in this context, saying that's the standard under which an employer does not have to provide an accommodation if it would be an undue hardship on the employer to juggle their work schedules to, or to somehow otherwise interfere with their operations. And then there was some litigation around the EEOC guidance. And then in 1972, Senator Jennings Randolph proposed an amendment which would, for the first time, put into the statutory language of Title VII this idea of it's not just about you're hiring or firing somebody on the basis of their religious identity. It put in the provision that says employers are meant to reasonably accommodate the religious needs of their employees as long as doing so does not impose an undue hardship on the employer. So the amendment took that phrase from the EEOC guidance. And at the time, the senator said he saw this amendment as furthering what the founding fathers intended, protecting the protection of people's religious freedom and the opportunity to earn a livelihood. So that's 1972. This is a great country we have here in the United States. Everything gets litigated. Much of it ends up in the Supreme Court. And so in 1977, that provision lands in the Supreme Court in a case called TWA, Trans World Airlines of blessed memory, versus Hardison, in which a worker is seeking an accommodation for having, again, holy days, Sabbath days accommodated in the workplace. And there's a little bit of a unique context in that case, which we don't have to dive too deeply into, but a lot of it had to do with the fact that being an airline, there was a collective bargaining agreement between the union and the airline as to work schedules and seniority and all these sorts of things. And in the context of that and deciding that Hardison's request for religious accommodation could not override the seniority provisions of the collective bargaining agreement, the Supreme Court along the way said the threshold or the get out of jail free card for the employer to not have to give the accommodation is if it would impose a de minimis difficulty on the employer, not an undue hardship, or I should say, the court defined undue hardship as a de minimis standard, basically saying any minimal inconvenience to the employer gets them off the hook for a legal obligation to accommodate their employees' religious needs. And so, frankly, in the decades since then, we, the Orthodox Jewish community and the Seventh-day Adventist community and many others in many other faith communities have had people in our communities that have needed religious accommodations in the workplace, whether it's for time off and scheduling changes, whether it's in some contexts wanting to wear religious clothing, whether it's a yarmulke for a Jewish man or a headscarf for a Muslim woman, or, by the way, also conscience issues that come up. Various kinds of workers, similar to the example of the other Supreme Court case, although that, again, as was said, that's in the free speech context. Web designers who work for web companies and don't want to work on obscene websites, or you can imagine all kinds of scenarios that want to have their religious commitments accommodated as much as possible. Now, it's important to note here that even in the statute, even in the EOC guidance, and even under the litigation, it's not an absolute right, for a person to walk into their boss and say, my religion requires me to do X, and you must let me do X. It's, on any of these iterations, it's a balancing test. It's something that ultimately there's a recognition that you can't have a situation in which employees can walk in and just get out of their job responsibilities entirely, disrupt the workplace entirely. We want businesses to be able to function and to sell their products and to provide livelihoods for their workers. But the question is, how hard does the employer have to try, so to speak? How much is the law going to prod the employer to say, no, you really need to make an effort to accommodate your employees' religious needs, because we understand, going back to what the senator had in mind, right, we understand that freedom of religion in this country is not only about the right to believe what you want to believe, but it's about the right to act in pursuit or in conformity to those beliefs, right? That's why the First Amendment, the relevant provision of the First Amendment, is phrased as the free exercise of religion, not just freedom of conscience, because the founders understood that religion is not just about belief, it's also about action. Let me just wrap up with one broad point and then hand it over to Todd. One of the things that you might be wondering, and the Supreme Court talked about in its oral arguments and its consideration of the Graf case, is, wait, so if the Supreme Court interpreted what was in Title VII, from our perspective, wrongly, right? Undue hardship sounds like it's something the employer has to really make an effort. De minimis is not that, right? A minimal inconvenience is not that. Why, this is not a constitutional ruling, this is a statutory interpretation ruling. Why didn't Congress just come back and amend the amendment, so to speak, and say the court got it wrong and we're clarifying what we meant? Well, it's not for lack of trying. This is something that Todd and I spent too many years on in the wake of these and other court rulings. We had legislation that was broadly supported across the religious spectrum. including the LDS Church and Seventh-day Adventists and Orthodox Jews and liberal denominations of Christianity and conservative denominations and so on and so forth. We had a bill that was called the Workplace Religious Freedom Act for many years. It had bipartisan sponsorship, including odd bedfellows. Like the last time it was moving in Congress, the lead sponsors in the Senate were Rick Santorum and John Kerry. Not two senators that you found on bills together very often. But you had, initially there was opposition from business groups, Chamber of Commerce, National Association of Manufacturers, who basically, it wasn't necessarily about this law in particular, it's just they are generally opposed to the law telling employers to do anything, one way or the other. But the more significant opposition, and this is something that's relevant to some other topics that'll be talked about around the conference and were even related to in the opening session, were from those who view religious liberty and religious freedom as a very conservative, small c conservative political movement. And folks in the gay rights community and folks in the women's reproductive rights communities who looked at this kind of issue and said, oh, this is going to provide another tool for people to interfere with other civil rights that they care about. So it'll provide a tool for pharmacists to not provide, to not dispense birth control prescriptions to women who are legally entitled to them. And you're going to have some conservative pharmacist who's going to get in the way of a woman getting her birth control prescription. Now, we can get into the discussion. We can explain why that legislation would not have done that, or why the Supreme Court ruling in favor of Mr. Groff won't necessarily do that. But those kinds of sources of opposition were what stymied the legislation for many years. Hopefully, that does not come back to bite us in the Supreme Court. A lot of the Supreme Court justices were raising this point about, well, wait a second, why doesn't Congress just fix this? Why do we, the Supreme Court, have to fix this? Had we known that we never would have passed the legislation, we would have saved ourselves a lot of time and not spent all the time on it and not given some of the justices pause. But again, I'm happy to talk about that more and turn it over to Todd at this point.
So with the abject failure to get RFAR passed, and it was, across many Congresses that predated me, I think it even predated you, Nathan, we started looking at sort of other options. And the idea of challenging in the Supreme Court had been sort of in the background, but quite frankly had not really been challenged. To the best of my knowledge, up until the events I'm getting ready to talk about, there had been no cert petition asking the Supreme Court to change its mind on the TWA versus Hardison decision. And there's a number of reasons for that, including, and this came up in oral argument as well, getting the court to overturn statutory decisions is historically harder. Because Congress always has the authority to overrule, and they do that in certain contexts all the time. Tax law. Justice Ginsburg's husband was a famous tax lawyer at Fried Frank, and he used to joke that she should let him write the opinions because the Supreme Court is just notorious in that legal community for getting it wrong, and Congress undoes stuff they do all the time. That is less the case, though, in civil rights laws, right? The court has been very hesitant to change its jurisprudence there, and that was kind of what we ran into. So fast forward to, say, 2018-19 timeframe, and I should say, and this is going to be, I'm going to talk about this sort of in the third panel portion of this, is the Adventist Church has a pretty robust program, of which I'm part of, on helping church members, and I'll talk about that later. But we had a gentleman down in Florida, actually Orlando, where Gene got stuck in, who worked for Walgreens, and probably in a job you would think, working in a store. Rather, he worked at the Walgreens call center. And his job was a trainer. So as they bring new call center people in, he would train them. It was him and one other person. And they had a situation back, I'm trying to remember the years here, 2015, 2016, where Walgreens, they had a couple different call centers around the country. One was in Alabama. they got this order from the Alabama Pharmacy Board saying, listen, you could call the phone up and say, hey, I want to refill my prescription. The person would work on the computer, tell you when you could go pick it up if you had any refills available. And Alabama took the position that phone call could only be handled by a pharmacy or pharmacist assistant, of which these call center employees certainly were not. And so they gave them like just a handful of days to not do that. So Walgreens decided, well, we will transfer all of these phone calls to Florida where anyone can pass out drugs. And so on a Friday afternoon, my guy by the name of Daryl Patterson gets put on his desk as he's training this new training curriculum that he was supposed to do starting the next day, Saturday. He called around after he got off work, couldn't switch out, couldn't do anything, told them, I'm not going to show up. They sent people there anyway, thinking, I guess, he was bluffing. Long story short, though, they ended up getting the training done in the time period. They transferred all the calls from Alabama, and they didn't suffer any adverse consequences, and they admitted that in depositions. But they told him, they said, listen, unless you promise to work on the Sabbath in the future, if need be, you're terminated. Or maybe you can go back to a call center representative, which is a position that paid like a third. But even there, we may not necessarily accommodate you. In fact, one HR person said, it's our policy not to accommodate. So much to our surprise, Mr. Patterson lost in what's known as summary judgment, which means it never even got to the court. Judges said undue hardship. So we ended up taking it to the 11th Circuit Court of Appeals, and we lost there as well. We then, and this is why it's Gene is, I said the joke was, the role of Gene Schaerr is being played by James Phillips today. So Gene was helping us with our appeals, and we decided, and I'll be quite frank, Gene had to talk me into this. We made our third sort of argument was, listen, this law violates your interpretation of Title VII, just violates what the meaning of it is. You should reconsider and change the ruling on Hardison. Alternatively, and in Nathan's timeline there, the Hardison case actually was dealing with a termination that occurred before the 1972 amendments and actually was being made underneath the EOC guidance. So there was an alternative argument that, in fact, the Supreme Court had never actually decided the 72 amendment language, the statutory language, even though every court of appeals had interpreted it that way. So we file our cert petition, and we get to amicus support and so forth, and we're hoping we got some attention. And then what ended up happening was the Kennedy case that Nathan mentioned. That was the football coach out of Bremerton, Washington, right? I'm sorry, James mentioned. That case goes up to the Supreme Court for the first time. And that was on what's injunctive relief. And the Supreme Court turns it down. And they say, no, we're not going to hear this at this time. But four of the justices filed a statement regarding the concurrence and said, well, we know that Mr. Kennedy, or Coach Kennedy, is only bringing his claim on, it was speech grounds at that point. And they listed all these other categories, and they said he's not bringing a Title VII claim. And I'm like, maybe that's because the Title VII claims are so weak under Hardison, and put a line in there is about, well, maybe in the appropriate case, we, the Supreme Court, could revisit that in the future. And we're like, well, that gets everyone's attention. And of course, we had Patterson pending at that time. And people who follow the court much closer than me say that those were not an accident, right? We had put that issue on their radar. So what that ended up doing was putting this issue squarely before what I'll call the Supreme Court Religious Liberty Bar. Our case, the Patterson gets briefed and everything. It goes up. They ask for the Solicitor General's view. This was under the Trump administration, Bill Barr. The administration, Bill Barr comes, and the administration takes the position, yes, Hardison should be thrown out. And it should not be, you should come down on the side of the petitioner. A little waffling in that. Unfortunately, the court did not take Patterson. There were some other vehicle problems with it, but they expressed an interest in the issue and said, well, maybe in the right vehicle. So this is two, basically neon signs from the Supreme Court were interested in this case. what ends up happening from there is how we get there. So our church had another case that was going up at this later that ended up going up the same time as another one from Tennessee. Ours was called Dalbristi. The other one was called Small. Those cases go up, and the court once again doesn't take the cases. But again, for the third time, in Dalbristi says, but we're looking for the right case. And of course, everyone that wants to get a case before the Supreme Court is suddenly interested in this. And then what ended up happening was Mr. Groff's case, First Liberty, ended up taking that, and a cert petition was filed. And of course, there was no Solicitor General input at that case when it was being considered because the SG was defending them. And then the Solicitor General's office ends up changing its view on whether or not Hardison should be overturned. And then we had the argument back in April, which, by the way, I just wanted to say, first of all, thank you to the Supreme Court for not messing up this panel by coming out with the decision this morning. And believe me, if you don't think we weren't on our phones, you would have been wrong. I will say, as far as let me just talk briefly about the case. The argument went okay. It wasn't as good as we'd hoped it would have been. So the justices who have not written an opinion for the April settings are Alito, Sotomayor, Kagan, and Kavanaugh. And of those two, I think only Alito or Kavanaugh are probably in line to write it. My hope would be Alito. He seems to be our strongest advocate. He wrote some of those statements that I talked about, and an argument seemed to be the most in favor. So that's kind of how we got there. And yeah, it was Gene and I both were disappointed that it didn't take one of our cases, but that is often what happens.
Great, thank you. So in the next couple of weeks, Groff's going to come down.
Okay.
You've heard the oral arguments. We also had a case just released last week dealing with the Voting Rights Act, where a majority of the court says that statutory stare decisis, so stare decisis is the legal doctrine for you non-lawyers out there, that the court should follow its previous precedents, right? Unless there's a really, really, really good reason not to. And as Todd explained, in the statutory context and interpreting statutes, it's even stronger than interpreting the Constitution. So we had a majority of the court say, hey, strong statutory decisis is still the coin of the realm, so to speak. What are your thoughts on how's Groff going to come out, or are we going to get a partial victory? What do you think?
There's a saying in the Talmud that prophecy was only left for fools and children, so I tried to be neither. But yeah, it seemed like, we were both at the oral argument. It seemed like I think we're fairly confident that, so to speak, our side is going to win. The question is, what is that going to look like? And there are basically two versions of it. One version of it, which I would expect if Justice Alito is the author of the opinion, is irrespective of that case, Justice Alito wants to write an opinion that says Hardison is overruled, it was wrong, and the new we are reinstating Congress's original intent, and it's undue hardship, and there'll be some more words about what undue hardship tries to mean. And Justice Kagan will probably write the dissent about how statutory stare decisis is really important, and as sympathetic as she is to Mr. Groff, Congress should be the one to fix this. The other thing that was sort of danced around by a number of the justices at oral argument was, they'll write an opinion that doesn't actually say the words, we are overruling Hardison, but effectively they're going to overrule Hardison. They're going to say, they'll find some way to say, well, in Hardison, when they wrote this, what they really meant was, and functionally it'll be overruled, even if it's not formally overruled.
That sounds like a John Roberts opinion.
Yeah, and depending on, and this gets really into the tea leaf, reading or internecine, court activities of how do different cases impact other cases, which I don't pretend to know how that may or may not occur, but those seem to be the two most likely paths.
Yeah, I would agree. I mean, when we left, there was, first of all, expectations were high, probably too high, well, definitely too high. We were just hoping for, 9 people just beating up on the SG saying, why shouldn't we just put in the, ADA standard, Americans with Disabilities Act standard? That is not what happened. you can only tell so much from a law argument, right? I remember leaving the Abercrombie argument with Gene, and we felt very uncertain about that, right? In fact, Gene clerked for Justice Scalia, and I kind of joked with him, like, what is wrong with your boss? Like, why doesn't he get this, right? And then he writes an 8-1 opinion that is everything we could have hoped for. So, one of the concerns we had with Justice Gorsuch kept trying to say, well, can we find some middle ground here? And, isn't there a ground here between what the SG is saying and what you're saying? And, we're like, no, that's not what we're looking for, because the SG hasn't really given us much as she's pretending to. And, was Gorsuch being sincere in that, or was he trying to bait her and just sort of ask questions and trying to explore this? You don't know. But I do think those are the two paths, and hopefully we'll get, an Alito opinion that will, because Roberts wrote one of the opinions today. And so that, just so you know, for those of you who don't follow the Supreme Court, generally speaking, for each sitting, one justice writes an opinion in that sitting. As far as the majority, they try to even it out. So one of the things that nerds like us do when it gets to the end of the season and you've got the big cases out there, well, who hasn't written an opinion from that sitting? And you can kind of guess who it's going to be. So hopefully it will be Alito.
Yeah, I mean, two other indicators in our favor, so to speak, and we're trying not to look at it through rose-colored glasses, are number one, nobody was actually defending the Hardison standard. Even the Solicitor General, I mean, she was doing some very fancy tap dancing. She was a very skilled advocate, but she was not saying no. Hardison was right. De minimis is right. Most of her argument was, even though Hardison says what it says, out in the real world, plenty of religious people are getting accommodated in their workplaces. Don't worry, nothing to see here. Please, continue on your way. At which point, Justice Alito, and this will give you he held up a very large stack of amicus briefs from all the religious groups, including ours and many, many others, who were all filed briefs to the court saying, Hardison's a problem, our people have problems, and so on and so forth. And Alito held them up and literally said to the Solicitor General, "Are all these people wrong? Like, what's the reality?" The second thing is along the same lines is that what I alluded to before about why we couldn't get the legislation passed. The advocates on the left, whether the ACLU, the Americans United for Separation of Church and State, even. A lot of them didn't file briefs in this case, and even the one or two that came in were not like the strongest, if you rule for religious liberty in this case, it's the apocalypse and people are going to be suffering. They really stayed out mostly. And so, again, justices and their clerks will do their own research. They'll see these arguments, but there was not a lot of pushback on the other side. To the degree there was pushback against the advocate for our side, in the court and in the briefs, it was, okay, well, even if we put a new standard in place, how is that going to be administered in a fair way, and it's not going to be too disruptive of businesses and so on and so forth. But that's normal in the course of any case.
You made a point that reminded me of something. I guess going with Justice Alito's comment. So there's some interesting statistics that. So the American with Disabilities Act, ADA, also has an undue hardship standard, and it's a very similar situation where, normally under the 1964 Civil Rights Act, if it's race or sex, you're just asking to not be treated differently. Whereas with religion and also in the disability context, what you're saying is, in order to be equal, I need to be treated differently, right? I need this accommodation to be on the same plane as everybody else. And so it's the same standard in the ADA, which was passed in 1990, but because of Hardison and the de minimis standard, what you get is employers will settle ADA claims about 90% of the time. They'll settle Title VII religious accommodation claims like 40% of the time or something like that. There's just a wide disparity with the same standard because of that watering down, which leads to a kind of a real world impact problem.
It does. One of the things the SG's argument was, like Nathan said, everyone wins, nothing to see here. And she cited a series of cases, recent cases, in which employers, what she said was, in which the court found it not to be an undue hardship. Now, what really happened there was they said there's enough to go to a jury on undue hardship. There were 5 cases. 2 of them were mine. 2 of them were Alan Reinaugh's, who's with the Seventh-day Adventist Church here on the West Coast, and then one other one that was in Alabama. So in your 5 cases, 4 of them come from one church that litigates in this area all the time and specializes in it. Maybe there is more of a problem here. If you have to spend most of your professional litigation experience specializing in this area to just survive summary judgment, and the biggest problem is it's all the cases that aren't being brought, right? People, I will, since I think this is mostly a Church of Jesus Christ audience, one of our first cases that we had was a Sturgill versus UPS. Sorry, not first case I had, not the church. And we had a jury, voir dire. And so, they call people up, and this young man came up and asked not to speak to the group. And he said, well, he said, I think he used the word Mormon. He said, and I work at Walmart, and I work in the tire shop. And he says, I have to work on Sunday because they just don't have anyone else. This is Walmart, people. They've got other people, right? But, I could tell he was very conflicted about this, very sort of whatever, because of his own faith, but was working. And, I really felt bad for him. I mean, I couldn't give him a card or anything. That really is discouraged for jurors. Give me a call. He was not he never made it on the panel. He was excused for cause. But I think those are the kind of scenarios that we really hope that a new standard will avoid.
Yes, and I think often we think of these types of cases as maybe religious minorities, right? Sabbatarians.
Right.
Folks whose Sabbath is on Saturday, or people who wear religious garb. But, for members of the Church of Jesus Christ of Latter-day Saints who are converts and maybe lower on the socioeconomic scale, to suddenly feel like, no, I can't work on Sunday, and to have this challenge and maybe not to be able to get Sundays off, and so it's hard to get integrated as a new member of the church because they can't go to church. It can be a problem. And so let's assume Groff comes out in some positive way, where the court gives a little bit more teeth to the undue hardship standard than the weak sauce that it currently is. What should religious communities do to take advantage of that, so to speak?
So let me just talk briefly, and I'm not trying to turn this into a Seventh-day Adventist lecture, but it was felt amongst the panel, organizers, that may be helpful to describe sort of the structure that we have. And I promise I'll make this quick. Because the reality is a lot of individuals don't know who to turn to. Most employment lawyers have never handled a religion case, or if they handled one, they're never going to handle another. And it is kind of a specialized area. And there's a direct relationship between social economic status and education levels and who gets accommodated. If you are, when I started out as a lawyer in 2000, I wasn't a practicing Adventist. I was raised in the church. 2 or 3 years in, I started keeping the faith. When I told the partner that, he said, oh, and was very interested in it. It was never a problem. So our first stance, first of all, we have a manual and everything. It starts off with our pastors. Most people just need a letter, right? Most people who have a Sabbath problem, HR just wants a letter they can throw in the file. So we have a form letter, that we talk to pastors about. The next step is we have public affairs and religious liberty directors. Most of them are attorneys, some are not, and they have a specialized specialty training in how to handle religious accommodation cases. And that's done at what we call our union level, which James and I were talking about, roughly equivalent to a Church of Jesus Christ area. It's multiple states combined together. We generally have one sort of serious inquiry that the parole director has to handle annually for about every 10,000 church members, right? So that's roughly the incidents that come up. And then all of those turn into cases. And then they will work through the EOC process. There's a fair amount you need to do there. You got to file a complaint within 300 days. You got to exhaust. There are multiple ways to mess this up and for church members to say things that they don't realize are going to hurt them. And so that's what the pastor and the parole director is designed to do, is to help them and get it resolved. And the vast majority of them get resolved. And then after that, if they can get it resolved, and once a right to sue letter has been issued, which is sort of the next administrative standard, that's when my office comes in and we partner with local counsel and we head up the litigation. So there is a defined system in place of people who, experts, I guess you call them, in this area who've handled them. And then we talk and work together and so on. And so, that's why I think if you look at the case law in this, there's a significant number of Adventist cases. It's not just because we handle, but because we have a system in place.
Great, thank you. Well, we've got about 20 minutes left, so we'd love to open it up to any questions that you might have for the panelists.
So my name is Daniel Benson. Two of you have met me. It seems that people who would not want to see Mr. Rock win and are opposed to a more kind of expansive protection for religious liberty in the private employer workspace, they kind of fall into, maybe the reasons are one of kind of three areas. Maybe they're typically, they're in favor of religious liberty as a general matter, but they're also very libertarian, and they don't want the government kind of messing with private business. Maybe they're typically very pro expansive anti-discrimination laws, but they're worried about the intersection with LGBT issues or with contraceptive access, like you mentioned. Or maybe they're just not, maybe they don't care, and maybe they're like, well, I have to work on the weekend. I'd love to go camping or whatever I want to do on the weekend. Why should I have to work and you don't, because your reason is religious and it's not? How do you think in kind of the public perception area, people who want more protection in the workspace for religious liberty can reach out and help people understand the importance of religious liberty protections in the workplace and maybe assuage some of their concerns or respond to some of that opposition?
So let me talk, if I can, I'm going to talk about one of that, and that is sort of the expansive group that, is expansive for protections generally, but this is, the intersectionality issues, which really boil down to LGBT issues and reproductive rights. And I think what we tried to do there, and this was one of the two, I'll call Adventist briefs, so they were filed by different legal entities, no violation of the rules. And what we pointed out was there are states like New York that's had this for a number of years, I think like 20 years. California's had the higher standard for a decade. Canada's had the standard since the 1980s, right? And all of these places, you can't point to the hypotheticals they come up with, or the person that wants to put a sign in their thing that says God hates gay people or enter a pejorative or whatever. Those cases just haven't come up, and so I think that brief, which didn't get referenced directly, was designed to alleviate those concerns. I will say it's interesting. Two words that did not come up in the oral argument: vaccines, thank you, Lord, and two, LGBT issues. None of those came up. And I think vaccines didn't come up because everyone's tired of that issue, and I think LGBT didn't come up, I think in part because of the arguments we made.
I think a couple other points. One is, it's very important to underscore that, again, even if we get the preferred Justice Alito opinion that he checks the draft with me and Todd, and so it's like perfect.
You didn't get your email yet?
No. Fundamentally, again, it's still not, pardon the term, it's not a trump card for the religious worker. Like, it's still a balancing test, and part of the balancing test, again, let's just use the pharmacy and contraceptives example, right? CVS or whatever, like CVS has a right to sell legal prescriptions. Those prescriptions include birth control. A religious pharmacist, right? A person chooses to go into to be a pharmacist. That's their choice, right? They do not have the right under this or anything else to single-handedly, so to speak, block CVS from conducting legal commerce, right? And sell and dispense birth control pills. Now, if we get a good opinion, they'll have the right to go to the manager in their CVS and say, I'd rather not be the one dispensing the birth control pills. There are 3 other pharmacists on duty the same time that I am. I would like to just hand the prescription paper over to my colleague, and they'll give it out. And that'll be the accommodation. And so I think it's important for people, and that'll apply in all kinds of other contexts. And so people need to understand that this is not the right for religious people to, impose their personal beliefs and their personal commitments and agendas on coworkers or on customers, et cetera. And I think that also ties into the that also ties into what was talked about at the opening panel, which is I think it's also important that this is used as an opportunity by faith communities to engage more broadly and say, look, we're living in a time in large parts of American society where things are, yes, very divided and divisive. We're also living in a time where the corporate sector, the business sector, is going through this DEIA, I don't know if it's a revolution anymore because it's already here. And it's important that religious, the interests and the needs of religious people of different religions is incorporated into and integrated into the whole DEIA world. Because that's part of your workforce, and that's the personal commitments, and that's the identity of these people. And while we're going through and trying to make everybody feel comfortable and valued in good ways, and accommodated appropriately and treated appropriately in the workplace, there's no reason why Jews, Adventists, evangelicals, et cetera, shouldn't be part of that rubric and approach by workplaces as well. And that's part of the story too that has to be told.
Great, thank you. Boy, a lot here. Yes.
So my husband actually just ran into this kind of situation. He's working at a care center for psychologically disabled, and they wanted him to work on Sunday, and he requested several times not to work on Sunday, and they could have found somebody, but they had been working on Sunday anyway. So as you've been thinking through this issue, I told him about this case coming out, and he should fight for his rights. But if this case goes the way you hope it will, and assuming that that there's more accommodations in the workplace for religious people, that how does that get passed down? So small businesses like this, so you're emphasizing that the balancing test. I assume their policy is not likely to change. And so for people like my husband who don't have access to the whole Seventh-day Adventist
That's not necessarily true.
well, I mean,
We help non-Adventists.
or didn't know,
Yeah.
right? So maybe we didn't know that we don't have access to this whole system, and this small business not likely to change their policy. So I guess my question is, how do you kind of get the memo down to the small business people to know that if somebody comes in with this kind of a complaint, that how did that person know that if it's just a balancing test, how do they kind of work it all out? Does that make sense?
Yeah, I think that's where our parole directors and so forth, I think a system where we contact and work with them and give them the law. They often encourage them when someone who's a lawyer calls them up and says, hey, you're doing this and this wrong, that often focuses their attention. It often causes them to call their lawyers or to reach out to HR professionals. What'll happen after Groff? There is an entire industry, and it seems to be in all professions, of training, continuing legal education, continuing HR, and so then SHRM and all the other organizations are going to put in, here's the new religion standard training. So there'll be a lot of materials out there, and I think the way it gets down to them is through education, through either their HR person or if it comes up, trying to educate them about that. But believe me, there will be a lot of HR conferences on this after Groff.
Just one important fact. Title VII of the Civil Rights Act does not apply to employers of fewer than 15 people. So if you're talking about a really small business, it doesn't relate to them. There might be state laws that deal with it because they usually have lower numbers, but that's important to know too.
Yes, sir.
So I'd like to hear comments from both of you about the significance of a presidential decision about who the next Supreme Court justices are, because we're talking about the opinions and how it differs so much from one justice to the other justice. So just educate us on the significance of that. You talk about a president running, but of what can happen depending upon that president.
Excuse me, and if you guys could just repeat back the questions that
Oh.
we did for the recording.
So the question was, what's the significance of presidential appointments of Supreme Court justices, given the variety of the justices on the court, and how that will affect the strength of an opinion and the like?
I mean, I'm happy.
I mean, it's not unique to this area of the law, right? We've seen in all different kinds of contexts. I think in this case, or these cases, the fact that there are more justices on the court who I would call religious liberty friendly is definitely, giving us optimism that this, like some others in recent years, are going to be ruled for what, in our way, so to speak. But I wouldn't, by the way, I would point out that it's not, a clean, it's the Republican appointees that are pro-religious liberty and it's the Democratic appointees that are not. Elena Kagan, I don't know how she's going to go in this particular case because, again, she has these statutory stare decisis concerns, which she talked about a lot at the arguments. But there have been religious liberty cases in recent years where Kagan, wrote the opinion or was a decisive vote. The one that comes to mind is the one about the clergy.
Hosanna Tabor?
Yeah, Hosanna Tabor, where she actually laughed out loud at oral argument at the solicitor. This was during the Obama administration. The Solicitor General was making ridiculous arguments about how narrow the right of the ministerial exception is, and the right of religious institutions to hire people that are committed to that particular religious faith. And she was one solidly on our side that. So it's not predictable necessarily in a partisan way, but it's definitely impactful.
Yeah, I would say I was kind of disappointed with Kagan's concerns. I was hoping we might be able to get her. We'll see. She might find a way around that, right? She might find a way to rule in favor of us and address her stare decisis concerns. Real quick story, by the way. I've never seen Nathan quite as worked up as after the Hosanna Tabor arguments out there on the media scrum at the Supreme Court, just lambasting the Obama administration for the position they took, which, by the way, they got precisely 0 votes in their favor, which if you can't even get Ruth Bader Ginsburg on your side, then you've taken maybe a little extreme position.
Great. Yes, sir.
Both of you, as has the Church of Jesus Christ of Latter-day Saints, have been involved in the Fairness for All effort in Respect for Marriage Act. With Republican control of the House now and in the passage of the Respect for Marriage Act, what do you see legislatively as far as progress on Fairness for All going forward? What is the vehicle?
Realistically, there's no vehicle between now and the next election, congressional and presidential elections. The LGBT on the LGBT side, I mean, I think they're gonna reintroduce the Equality Act, which is their flagship bill, sometime this month. But they are very busy, from their perspective, playing defense on a whole host of pieces of legislation that Republicans in the House in particular are putting forward with regard to trans issues. And that's what they're focused on. And on the religious liberty, the proactive religious liberty side, I think, even if, first of all, a couple of key members in the Senate, like Rob Portman, who was crucial to the Respect for Marriage Act turning out the way it was. He retired, as did Roy Blunt, who was a key vote among Senate Republicans. So I think, at least for the next year and a half, 2 years, whatever it is, our coalition has to keep doing its work in terms of laying groundwork. But it's hard to see a scenario in which that kind of legislation is moving before calendar year 2025.
Also, losing Chris Stewart, who's the lead in the House, was not helpful either. So that is going to impact it as well. But yeah, I think Nathan's right. Like, nothing happens until 25.
You had a question here?
I have a couple, but you can take time. I'll ask the simplest, which is I think a lot of people here might be wondering, when you've got a case, what are some factors that you look at to decide whether it's meritorious and whether it's
Yeah. the primary issues that we look at for the church is, first of all, we have our stances, the church has that, just to be clear, Todd doesn't develop. And, we look at the vehicle, is this the right one to take? What's our ability to have impact? And, we also look at, the church member itself is a factor, like in taking an actual case, right? So, a lawsuit is a long, expensive, resource-intensive issue, and so there are some just sort of case-specific things. I mean, even though we don't take these cases for money, believe me, we do not take these cases for money. In a case with no damages, like where a person got another job very quickly, unless there's a bigger issue that you can have there, which we actually have one right now, that's a hard case to take. Now, we do have one right now, actually pending here in Utah against an airline, a regional airline. And the damages there are not particularly high, but we are trying to get broader for pilots in the aviation industry. So you got to look at, those factors as well. Because if you got a case where a person had a few $100s in lost wages, the judge is just going to hate you. And it has a chance to make bad law, quite frankly.
Yes, just.
So go back to the Groff case. If with the two possible victories you mentioned, with the first, the kind of milquetoast, split the baby kind of victory, what's the next frontier? How do you follow up on that kind of victory? Keep pushing on it. And with the second one, the more robust reinstallment of the undue burden standard, what is the new standard? What kind of work does it do? What gets balanced against what?
So on the first one, I actually think that there will probably be some future litigation, but in the near term, the focus, from my perspective, is much more with the EEOC and the Department of Labor and the Small Business Administration and getting the executive branch, where, by the way, we have allies, despite what the Solicitor General did. If the court rules in our favor, even if it's, again, not the slam dunk, they, I know, are ready to put out guidance and work with us on pushing out into the world. Yes, the standard is higher. Now, what that means also, though, relates to the second point, which is, which everybody, again, both sides acknowledged at the oral arguments. Because this is not a bright line rule, it's very context specific and it's very fact driven. And what Walmart is going to be required to do to accommodate religious employees is going to be different from what a 25-person widget company is going to do. And so we're going to have to, besides working with government agencies, there will be those who will engage with the Society of Human Resource Managers and other business groups as they are, try to help them or to try to partner with them and influence them on how they communicate this out to business owners in terms of how they're implementing it. I think it's also important to underscore, while this is a very important issue for the Orthodox Jewish community, the Seventh-day Adventists, and many other faith communities, we shouldn't lose the context of, we do live in a country in which, even though there are problems in this arena, the majority of people don't have these problems, right? It's not like it's not like every day or every other day people are getting fired or people are having trouble at work because they have a callous, employer who is saying, darn it, I'm going to make you work on Christmas, Passover, whatever, et cetera, et cetera. People do generally try to be accommodating. And by the way, in the current, employment environment, in which it's a seller's market, employees have the upper hand these days because of the economy. This is another element, alongside how many days can you work from home, that also helps move things in the accommodating direction.
I might just add one comment. Supreme Court, most cases don't get to the Supreme Court, right? I mean, here we have, a 45, 46-year gap in cases. It gets flushed out in the lower courts. So once the Supreme Court comes down with its Groff standard, we're going to have to figure out what that means. And so what's going to be really important is lower court litigation and figuring that out. All right, it is 11:09, so I should probably call it at that. Would you please join me in thanking our panelists?